So today we'll be discussing about writ and types of writ in detail. Hello everyone, welcome to my channel. If you're new to my channel, then please do subscribe for the new videos. Well, we already know part to issue writs rest with Supreme Court as well as High Court. First of all, we have to understand what is writ and from where we have taken this provision. Well, writ is a legal order issued by Supreme Court under Article 32 and High Court under Article 226 for the violation of fundamental rights. This provision has been taken from the British Constitution. This is simple and general definition of writ. Let's understand this in detail. So far we have discussed many times Part 3 of the Indian Constitution, which has given us a lot of rights. But what is the value of these rights if there is no one to protect them? There is no one to take guarantee on their violation. There should be someone who can take guarantee. Otherwise, what is the point of giving so many rights? Therefore, the Constitution of India has called Supreme Court the guarantor of fundamental rights and has given an extraordinary power to issue writ in order to enforce the fundamental right if violated. So, writ is a legal order which is issued by Supreme Court and High Court. But if needed, Parliament can empower other courts also to issue writ. Now, the question is, who can file a writ of petition? Basically, two types of person can file a writ of petition. Number 1, any person whose own fundamental right has been violated by the state. Such person is called aggrieved person, and other person whose own fundamental right has not been violated, but that person can file a writ of petition for the interest of the general public. Like any group of people that is in disadvantage, such person is called public spirit person. So this person can be any individual or organization or NGOs, etc. One more thing we should note down that a person from this group can also file a writ of petition in the court. This type of petition is called representative petitions, where a person seeks justice for himself as well as for his group. Now the question is, against whom the writ of petition can be filed? The answer is that writ petition can be filed against the state or body that comes under the definition of state. Now for this we have to go through Article 12, in which the definition of state has been talked about. For now we'll take some examples to understand that what comes under the definition of state. For example, central government and parliament, state government and state legislature, local authorities like municipalities, municipal corporation, nagar palika, jilla panchayat, statutory and non-statutory bodies like National Human Rights Commission, Central Bureau of Investigation, government or semi-government institutions or institutions which are fully or partially founded by government, etc. These are the major examples of state and bodies which come under the definition of state. In short, writ is a legal order issued by Supreme Court or High Court against the state or authority of state for the violation of fundamental rights. Now the third question is, where can a writ petition be filed? As we already have discussed, writ petition can be filed in the Supreme Court and High Court. Supreme Court has got this power under Article 32 and High Court has got this power under Article 226 of the Indian Constitution. The right to move to the Supreme Court in case of violation of fundamental right. Power to move to Supreme Court in case of violation of fundamental right is in itself a fundamental right, since it is contained in Part 3 of the Indian Constitution. Apart from these two courts, Parliament can empower other courts also to issue writ. But As of now, the Parliament has not taken any other courts the power to issue a writ. But if ever needed, it can be done. Now, writ issued by Supreme Court or High Court can be of different nature, or you can see that of different types. So the type of writs are Habeas Corpus, Mandamus, Quo-Warranto, Certiorari, and Prohibition. These writs are issued in different situations and in different circumstances. Now we'll understand each one of these one by one. The first type of writ is Habeas Corpus, which means to have the body of. I repeat, which means to have the body of. The writ of Habeas Corpus is issued by the court when there is an unlawful detaining of a person by any public authority or private individual. And private individuals are those who do not belong to any group, company, or organization. Now, this person who has been detained unlawfully or illegally can file a writ of habeas corpus in the court against the authority who has detained him. On behalf of this person, his family also can file a writ of habeas corpus in the court. Now, in such situation, court asks to have the body of the person who has been detained. That means the court seeks to produce the person before the court. When the person is produced, the court questions the detaining authority. What were the reasons for detaining this person? If the reasons are found valid by the court, then a writ will not be issued against the detaining authority. But if the reasons are found invalid by the court, then the writ will be issued against the detaining authority and action will be taken, and the detained person will be set free. After that, person can also claim for the compensation. Second type of writ is writ of Mandamus, which means we command. Writ of Mandamus is issued by the court to direct a public authority to perform the legal duties obliged under the law to do, which it has failed to perform or refused to perform. Under this comes central or state government, public official or public corporations, inferior courts, etc. A writ of Mandamus cannot be issued against any private individual, the President of India or the state governors and the Chief Justice of High Court. Now, let's take an example to understand that when a writ of Mandamus can be filed. We took this example in the last video as well, where we saw that a boy applies to take admission in a college which is a government college, and the authority of that college refuses to take admission just because the boy belongs to a different caste or maybe a different religion. In such situation, the boy can file a writ of Mandamus in the court against this institution. After that, court can take action against this institution. Now, suppose this college has got a discretionary power where it want to take admission or not. Like there are some institutions who take admission on the reservation basis, means it is not mandatory to take admission. In such situation, a writ of Mandamus cannot be issued. Now the third type of writ is writ of Quo-Warranto, which means by what warranty or by what authority. A writ of Quo-Warranto is issued by the court against a person who holds a public office unlawfully. Public office means which performs a governmental work or which is established by the law or any elected person. If such person administrates any public office unlawfully or the person is not authorized to hold that office, then the court can issue a writ of Quo-Warranto against the person and can remove that person from his position. This writ cannot be issued against any private office. Let's take an example to understand when a writ of Quo-Warranto can be issued. Suppose a person is appointed as a judge of a high court, and later it was found out that judge is not qualified enough for that position and yet he remains at the same position. In such situation, a writ of Quo-Warranto can be issued by the court against that judge and can be removed from his position. Now the next writ is a writ of sorcery, which means to be certified. Writ of sorcery is issued by the Supreme Court or High Court to the lower courts to transfer the matter to it for the proper further processing. Or it can be issued by Supreme Court or High Court for questioning the order already passed by the lower courts. Questioning the order means cancelling the order given by the lower court. This happens when the lower court acts beyond its limits of its power or makes mistake while giving the judgment. In such situation, writ of sorcery can be issued by the higher courts to its lower courts. Let's take an example to understand this. Suppose there is a dispute between Ram and Shyam for our land. This land is in district A. Ram registers a case in district A and at the same time Shyam also registers a case in his own district, that is district B. If district court of B gives a judgment in the same matter, will that be right? No, it doesn't come under its jurisdiction and it will also create a confusion in such situation. Higher court can issue a writ of sorcery against the lower court asking that, are you certified to take the decisions? And also the higher court can transfer the case to itself for the further proceeding. Now moving to the last writ, that is writ of prohibition, which means to stop. The writ of prohibition is actually similar to writ of sorcery. It is issued by the same authority and is issued against the same authority, means it is issued by the High Court or Supreme Court to its lower court. The only difference is the stage at which they are issued. Writ of sorcery is issued after the case is heard or decided. It is to cancel the decisions of the lower court. Whereas the writ of prohibition is issued while the processing of the case is going on. If the higher court finds in the middle of the proceeding that the lower court is acting outside its jurisdiction. In such situation, higher court, that is Supreme Court or High Court, can issue a writ of prohibition to stop the proceeding of the case, as we saw in the previous example. That is about the land dispute. If Shyam applies to the higher court in the middle of the proceeding, then the higher court can issue a writ of prohibition to stop the proceeding. So that's all about writ and types of writ. Thanks for watching. Looking forward to see you in the next video. Do not forget to hit the subscribe buttons if you haven't already. Happy learning and see you soon.